The following IWLA webinar, Food Safety Modernization Act, was recorded on July 18th, 2013. All information is accurate as of that date. Good morning and welcome to IWLA's Food Safety Modernization Act webinar, scheduled to run between 10 a.m. and 11 a.m. Central. My name is Joe DeGuzman and I am the Senior Coordinator of Member Marketing for IWLA. Today it is my pleasure to introduce our featured speaker, Mr. Pat O'Connor. Mr. O'Connor advocates on behalf of the 3PL warehouse industry before the Congress and the federal regulatory agencies, as well as in many states. Before we begin, I have a few housekeeping notes. IWLA's sales and marketing workshop still has seats available. Please go to IWLA.com for more information. There's also a video of one of our speakers, so go ahead and check that out. Some protocol for the webinar. During the duration of the webinar, all participants' lines will be placed in lecture mode and muted. To collapse the interface window on the right-hand side, please click on the orange right arrow. Please do not minimize that application, otherwise you won't be able to see the presentation. At the end of the presentation, there will be a Q&A session. To submit questions to that, please use the questions box in that user interface window. If you have any technical issues, please use that questions also, and I can respond to you directly. And with that, I'd like to hand over the presentation to Pat. Pat, go ahead.
Thank you, Joe, and good morning, everybody. Welcome to this webinar on the Food Safety Modernization Act. In the next 45 to 50 minutes, I'm going to go fairly quickly through what the U.S. Food and Drug Administration is doing with respect to implementation of the Food Safety Modernization Act. Hold on here a second. My slides are not advancing.
You might just need to click on that first slide. No problem. Click on that and then you should be able to advance your way through.
Well, sorry about this, folks. Joe, I'm getting this strange thing on the screen. Are other people seeing that?
No, I'm not seeing that. What does it say?
It says move this window away from the shared application, and then there is a rectangle flashing.
Flashing. Okay. Go ahead and hit escape out of the what's it called? There you go. And then go ahead back into slideshow mode.
Okay. Okay.
Click there we go. There we go.
Well, sorry about the technical difficulties. Food Safety Modernization Act was signed into law in January of 2011. I know many of the questions I get from IWLA members is, what does the Food Safety Modernization Act require me to do, and what are the compliance dates? When will I have to start complying with the Food Safety Modernization Act? Unfortunately, we don't have those answers yet. The Food and Drug Administration, FDA, is in the process, as we speak, of writing the regulations. Congress passes a law, and when Congress passes a law, it lacks a lot in the way of detail. It's up to the FDA to add in the detail and the substance. FDA is very behind in meeting the deadlines for writing the regulations. So until we actually see those regulations and we see the final regulations, and of course in the regulatory process the agency will first issue a proposed rule, and then there will be a comment period on that proposed rule. And once the comment period closes, then the agency will take anywhere from 18 months to 2 years to digest those comments and issue a final rule. I just go through that to try to set the table a bit so that you understand that we're in a kind of a lengthy period before we actually will know the specific details of the SMA regulations. Of course, once the final regulations are issued and the compliance date, the date by which you have to start complying, goes into effect, then it will be the FDA inspectors who will enforce those regulations, along with their colleagues at the state level. The thing that IWLA is doing through IWLA's Food Security Council is we are working closely with the FDA and allies in the food sector to try to influence these regulations before they become final. And in some cases, trying to influence the regulations even before they're issued as a proposed rule. It is much easier to impact and influence a federal regulation if we do it early rather than trying to do something after the final rule is issued. And as you folks well know, a lot of the authority rests with the FDA inspectors when they come into your facility. So we will be trying to do what we have been trying to do and we'll be trying to do going forward is make sure that the final rules, specifically those aspects of the final rules that apply to warehousing, are as clear as humanly possible, so to leave very little room for interpretation by an FDA inspector. One question I get is, well, why did Congress pass the Food Safety Modernization Act? Why are we faced with this multitude of new regulations? Why will we have to incur this additional administrative cost burden? The answer to that is the safety and security of the food supply chain has become a major issue. Of course, the food supply chain is now a global supply chain with food product coming in from China, Southeast Asia, virtually every corner of the world. We're no longer just a domestic supply chain. There have been incidents where contaminated product has entered the supply chain. The peanut issue of several years ago, the peanut paste, is a case in point. I would say the major food processors, major food manufacturers are very concerned that these incidents of adulterated food product are brought to an end. And that's why it was the food sector, the food manufacturers and the food processors, who actively supported and urged Congress to pass the Food Safety Modernization Act to set the ground rules for all sectors of the supply chain in moving food product from the fields to the table. The government, the FDA, and the Congress expect all supply chain partners to participate in the solution. I often refer to the supply chain now as a pipe, where product goes in one end and comes out the other. And anybody who has access to that pipe throughout the supply chain become responsible in the eyes of the regulators. And now we're seeing a situation where all partners in the supply chain will share compliance and liability responsibilities. More and more we're seeing, whether it's in food or pharmaceuticals or consumer products or in chemical products, that the 3PL warehouse is not able to simply say, I'm only following the instructions of my depositor or customer. We're now seeing your depositors and customers saying that you need to bear some of the responsibility. We're certainly seeing that from the regulatory agencies in the Congress. As FDA moves forward with these regulations, the large food processors and your customers expect 3PLs to work with them on policy solutions, on regulatory solutions. And that's why IWLA and the leadership of the Food Security Council are working very closely with groups like the Grocery Manufacturers Association, the Food Marketing Institute, International Association of Refrigerated Warehouses, International Food Distributors Association, the major food wholesalers, to make sure that we're all working together so that we all reach a solution that is equitable to all sectors of the supply chain. FSMA's schedule of rulemakings, FDA has a host of rules they have to issue. A couple that are already in effect, FDA's authority for mandatory recalls and the new registration requirements, and I'll cover both of those shortly. Two major proposed regulations were issued for public comment. One was specific to produce, and the other is preventive controls for human food. And I'll spend quite a bit of time talking about the preventive controls for human food. Because of a court order because of litigation brought against the FDA, that FDA was not moving fast enough on issuing regulations. Federal court has ordered FDA to publish proposed regulations by November 30 of this year for what's called foreign supplier verification, accreditation of third-party auditors, preventive controls for animal feed, sanitary transportation of food and feed, and intentional contamination, that is food defense. With final rules with respect to all these rules to be issued by June 15th, 2015. So you can see with that June 15th, 2015 date, we are a ways off from seeing final rules actually being issued. That being said, though, we already know that there are 3PL warehouses that are moving forward in trying to update their policies and procedures to start complying or be closer to compliance when these rules go into effect. Mandatory recalls. Unknown to most of us, prior to the Food Safety Modernization Act, FDA did not have the authority to mandate a recall. It could urge a processor to recall a product, but if a voluntary recall did not happen, FDA had to go to federal court to mandate that recall. This new law gives FDA authority to issue a mandatory recall order to the responsible party to cease distribution and notify all parties in the distribution chain to cease distribution. There's a key term in here, and that is the term responsible party. When we looked at the existing law, we recognized that responsible party included the 3PL warehouse, that if FDA were to issue a mandatory recall, everybody in the supply chain would be equally responsible for implementing that recall. In simple terms, not just your customer, but you also had to be part of the recall scheme. What we were able to do, though, with the help of Senator Lamar Alexander from Tennessee and some other allies on Capitol Hill, is get the recall language in the Food Safety Modernization Act modified. And this is the modification that actually exists in federal law right now. And as you'll see, if there's a recall, your customer has to provide to you the precise identity of the article of food covered by the recall order that you may have in your possession. And this was very important because we pointed out to folks on Capitol Hill that to date, or prior to this legislation, often you heard about a recall by watching CNN. We know with the peanut incident of several years ago, a number of IWLA members were handling product, had product in their warehouse that contained the contaminated peanut paste, but you weren't being notified directly by your customer. This recall language is at least a step forward to ensure that if there is a mandatory recall, you receive the necessary information you need from your customer. This has led to a question of recall insurance. We're hearing that more and more RFPs are asking whether or not the 3PL warehouse has recall insurance for food product. There's a lot of discussion going on today in the insurance industry about putting together a recall insurance product. FDA registration. One of the new changes in the Food Safety Modernization Act with respect to registration is that all food facilities that are required to register must renew their registration every 2 years. And that renewal has to be done in an even-numbered year. And that registration renewal window will be open between October 1 and December 31st of the renewal year. The next renewal will be in 2014. We've already gone through this in 2012. The first renewal cycle was from October 1st to December 31st. And for example here, if you had registered a new facility on September 30, 2012 with the FDA, you needed to re-register that facility after October 1st. So again, what the FSMA does is requires that your registration be renewed every other year. As you know, if you've done your registration, there's additional information now that FDA is requiring as part of that renewal process. An issue that has developed as part of the registration process. Under the original law, the Bioterrorism Act amendments of 2002, a foreign food facility must also register, and that continues today. The foreign facility, the foreign manufacturer, must submit a registration to the FDA, and as part of that process, designate a U.S. agent. Originally, that designation of a U.S. agent was only for the purpose of receiving notification, so that FDA would be able to send a notice to an entity here in the United States who is representing that foreign facility. There was no written concurrence of that agency status required. So your customer based overseas, when they registered with the FDA, could have listed you as their agent of record, and they did not have to advise you that they were doing that. Still was not a major issue. However, the role of the U.S. agent is expanded under the Food Safety Modernization Act. The U.S. agent now listed on the registration form is liable for the costs of FDA if FDA has to re-inspect a foreign facility. And FDA has inspection of foreign facilities underway, and they're on a schedule of trying to inspect X number of facilities over the next several years. So now the U.S. agent becomes the person first responsible if a foreign facility has to be inspected. The cost of that inspection is estimated at $30,000 to $35,000. And what the FDA will do is they'll send that bill to the U.S. agent, which could be the warehouse, and you'll have to pay it, and then you'll have to negotiate with your customer to recover that cost. Again, every foreign facility designates a U.S. agent. Until recently, the agent was only responsible for forwarding to FDA the notification. Now the agent is also legally responsible for paying the fees for any reinspection of a foreign food facility. Again, these are expected to cost $25,000 to $30,000. FDA does have a procedure for you to remove yourself from the registration process. So if you have reason to believe that you've been designated as an agent by one of your customers, there is a process that FDA has. I will say the process is not terribly efficient, but there is a process, a procedure you could use. One of the important rules that has been issued was on January 4th of this year, and that's the preventive controls for human food. There was originally a 120-day comment period that was extended to September 16th, 2013. And again, just to recap the rulemaking process, an agency will publish a proposed rule in the Federal Register. That proposed rule then will be open for public comment, written comment, for a period of time. And that's where we are right now. We're in the written comment period. They also will hold public meetings or public hearings to hear the reaction of the regulated community. Public meetings on the preventive controls rules were held here in D.C. In February, Chicago in March, and Portland, Oregon in March. I apologize, I just hear that you may not have been able to hear me for the last couple of minutes. On April 17th, an IWLA team, the leadership of the IWLA's Food Security Council, met with FDA at their headquarters in Rockville, Maryland. A summary of the preventive controls rules. It basically requires a facility, and I'm going to stress the word facility. This rule applies on a facility-by-facility basis. Essentially, you're responsible for what goes on within the four sides of your building. The process is responsible for what goes on in the four sides of their building, same with the retailer, wholesaler, etc. Each facility would be required to implement a written food safety plan that focuses on preventing hazards in food products. The rule also updates the good manufacturing practices, the GMPs. Who's covered by the preventive controls rules? The simplest rule of thumb is any facility that manufactures, processes, packs, or holds human food and is required to register with the FDA. So if a facility has to be registered with the FDA, that facility 99.9% of the time will be subject to the preventive controls rules. It applies to domestic food as well as imported food. As you know, the current good manufacturing practices do include a section for warehousing and distribution. The GMPs broadly address safety risks of foods held for storage and distribution. The revision, you'll see that in the second box on the screen, makes some changes to the GMPs for warehousing and distribution, or storage and distribution. Those who have reviewed that don't see it as a major concern. But it's important, though, just to recognize that this proposed regulation does include revisions to the good manufacturing practices. There may well be other sections of the good manufacturing practices that you comply with today for other reasons, and so you may want to make sure you go through the proposed changes to the GMPs. One of the things that we were successful in getting into the Food Safety Modernization Act was giving discretion to FDA to allow them to exempt warehouses where the food does not come into direct contact with the environment. This was discretionary authority given to the FDA in the law. Because of that, IWLA joined in a petition to the FDA asking them to exercise that authority. You can see our partners in this petition effort, a wide range of food organizations, American Bakers Association, Grocery Manufacturers Association, International Dairy Foods Association, etc. And the petition we submitted requested that FDA exempt from compliance those facilities that are solely engaged in the storage of packaged foods not exposed to the environment. Fortunately, the FDA, and several of us had met with the FDA prior to the proposed rule. Fortunately, the proposed rule includes a warehouse exemption to an extent. They did not give us everything we wanted, but they gave us quite a bit. For dry storage, and I'll refer to it as dry storage just for simplicity here, a facility solely engaged in the storage of packaged food that is not exposed to the environment is generally exempt from the preventive controls rules. You're exempt from having to do it in hazard analysis. You're exempt from having to have a written plan, etc. If you're a refrigerated warehouse, there's a modified exemption for warehouses that handle refrigerated food. Again, for refrigerated food, but food that is packaged and not exposed to the environment. Under this definition for refrigerated storage, or this provision for refrigerated storage, it applies specifically to what FDA calls TCS foods. These are foods that require time and temperature control for safety. The modified exemption does not apply for a food that requires cooler temperatures, such as chocolate in the warehouse. The modified exemption applies only to refrigerated food or TCS foods, Your customers should know if a product they're depositing in your warehouse falls into that TCS category. Again, with respect to dry storage, the rule you can see is in quotation marks, does not apply to a facility solely engaged in the storage of packaged food that is not exposed to the environment. When we met with FDA in April, we raised several issues with them. Probably one of the most important issues was, well, what is meant by solely engaged? And we had raised this with them at the 3 earlier public meetings that were held here in D.C., Chicago, and Portland, Oregon. Fortunately, at our meeting with them in April, they finally understood what we were talking about. The concern we had was that if a warehouse had to be solely engaged in the storage of food, that warehouse would not be exempted if it handled electronics, other non-food products. It took us quite a while to get FDA to understand that many warehouses would be multi-product facilities. When we met with them in April, the lead FDA official on this rulemaking finally said that he had reached his aha moment and understood what we were saying, and that it was not their intention to deny the exemption to a warehouse because that warehouse stored other non-food facility products, electronics, chemicals, etc. They specifically asked IWLA to submit rulemaking language, regulatory language to fix this, and that's a work in progress. We also talked about what do they mean by not exposed to the environment. That's a term that's subject to vast interpretation. They've asked us there to come back with specific regulatory language that we feel would address the issue. When I talked earlier about the end result of the rulemaking process is that the FDA inspectors will enforce the rule. These are two terms that we want to make sure the rule clearly defines for the FDA inspector. What is meant by solely engaged and what is not exposed to the environment? The third issue we raised is what about de minimis activities? You may handle only packaged food in your warehouse, but there may be times where your customer comes in and opens a 1,500-pound bag to extract a sample from that bag and then reseals the bag. There may be QA activities that go on where your customer comes in and does a QA activity, asks you to do it on their behalf. There may be grading of food products going on in your warehouse. We raised the issue of including de minimis activities within the scope of the warehouse exemption, and they were certainly receptive to entertaining language from us on this issue. The point that we'll be making, one of the points we'll be making in our comments to the IWLA, to the FDA specifically on this issue, is that these other activities such as sampling, QA, grading, etc., are already covered by the good manufacturing practices. And we will be pointing that out in some detail in our comments. And because they're covered by the GMPs, there's a very low risk associated with these practices. The refrigerated exemption, or we call it the modified exemption, certain packaged food for which refrigeration is required for safety must have temperature controls, monitoring, verification, and records associated. I'm not going to go through the text of this slide or the next couple of slides in detail, but just to summarize, if you have a refrigerated facility, you're going to have to establish and implement temperature controls, monitor those controls, keep a record of your monitoring. If there's a problem with temperature controls, take appropriate actions, document those actions, etc. You'll have to verify that temperature controls are consistently implemented by calibrating your monitoring devices, reviewing records, and then you have to maintain records, records that document the monitoring, records of corrective actions that were taken when a problem was identified, and records of documenting the verification that the controls have been put back in place. We have run these requirements by several IWLA members who have refrigerated facilities. And I've also met with the IARW, Association of Refrigerated Warehouses. Generally speaking, these requirements for the modified exemption do not seem to be too burdensome. That most warehouses already are doing this to be able to document the fact that when the product leaves the warehouse, that product has been properly stored in a refrigerated environment. That being said, there are two issues that we will address in our written comment to the FDA. One is, in the proposed rule, the FDA, the FDA discusses who's responsible for determining what the appropriate temperature and time control is. And they go on to say that it should be the owner of the product, but if the owner of the product doesn't provide it, then the warehouse can easily find that information in the technical literature. We made a very strong case that in the case of a 3PL warehouse, that it should not be the responsibility of the warehouse for determining or trying to find out what the proper time and temperature control is for that product. And we pointed out to them that in their rulemaking, they devote several pages to the potential threat to human health that exists when proper time and temperature controls are not kept. FDA responded very favorably to our arguments and said, fairly admitted, that they were really looking at this as a warehouse where the warehouse was the owner of the food product. That it was not their intention, they said, to require a third-party warehouse to determine proper time and temperature control. So we, again, will be submitting regulatory language to the FDA on this point. The other point that we will address is the regulation says that if you learn there's a potential problem with the refrigerated product, that you may not release that product into commerce. You can't ship it out from your dock. We will be advising FDA that in the case of a third-party warehouse, you don't have the contractual authority to make that decision as to whether a suspect food is released into commerce or not. We will be proposing to FDA regulatory language that essentially will say that the FDA, that you cannot release a product if you've been advised by the depositor or customer not to release the product. I trust people are still able to hear me. I'm getting a notice on my screen that there may be network connection problems.
We've been able. I've at least been able to hear you this entire time, Pat.
Okay. Okay. Good. So, with respect to the proposed rule for preventive controls, if you're handling packaged food, whether in a dry environment or refrigerated environment, there's an exemption, at least a partial exemption. But what about the warehouse that also engages in manufacturing, processing, packing of product? What about the warehouse who may blend products? What about the warehouse that does a variety of activities that kind of fall outside storage of packaged product? That's where you become then subject to the entirety of this proposed rule. You'd be required to have a written food safety plan that includes a hazard analysis, specific preventive controls, procedures for monitoring, and have a recall plan. You have to have a hazard analysis, identify and evaluate known or reasonably foreseeable hazards for each type of food, and determine which hazards are reasonably likely to occur. The preventive controls rule is HACCP-like, but it is different from HACCP in a number of areas. And I have to admit that I am not conversant on HACCP, so I can't specify for you what those areas are. But FDA makes it clear in the rule that this is not HACCP specific. Of course, HACCP applies today to seafood and juices. The preventive controls, again, this would be if you fall into that category that you do some manufacturing, some processing activities. Your preventive controls, as appropriate, must include process controls, allergen controls, sanitation controls, etc. The preventive controls must be implemented at critical control points, but also may be implemented at points other than critical control points. The recall plan, and this is an area that we will address in our comments. This again would be if you're a 3PL warehouse and you are engaged in some activity that would be considered deemed manufacturing or processing, you would have to have a written recall plan in place for that product, even though you're not the owner of that product. And that plan would have to include notifying consignees, notifying the public, conducting effectiveness checks, and disposing of recalled product. You know, that last point, disposing of recalled product, you may not be in a position to dispose of the recalled product because you don't own it. Someone else does. So at least on the recall plan piece of the preventive controls rules, as it applies to a third-party warehouse that may be engaged in some kind of manufacturing type activity, we will submit comments on that. Additional FSMA rulemakings, again, these additional ones now by court order have to be issued by November of this year. Foreign supplier verification, third-party accreditation, preventive controls for animal food, and then safe food transport and intentional adulteration. Let me just spend a couple seconds talking about 2 or 3 of these bullet points. Foreign supplier verification, this will be a requirement probably for the food processors. You as a warehouse may get pulled into this rulemaking to verify that the foreign supplier of the product is meeting the preventive controls rules at their foreign facility. Third-party accreditation and certification. I know many of you probably use AIB to conduct your audits, maybe AIB audits to BRC or SQF. This rulemaking will decide whether or not those types of third-party accreditation and certification will be permitted. Of course, we now have the Global Food Safety Initiative that is finalizing its warehousing and storage benchmark protocol that groups like BRC and SQF will have to be certified to. So we don't know for sure what this third-party accreditation and certification rule will do. I know I have talked to one of the standards bodies that has standards, and they have run their standard against the preventive controls rules, and they know that they will have to update their standard to meet the FDA proposal. Preventive controls for animal food, we expect that this will be very similar to the preventive controls rules for human food. We would hope that this preventive controls rules for animal food would include a warehouse exemption. Safe food transport, we're watching this one very closely, not from the perspective of the warehouse that may also have a transportation subsidiary or affiliate, but what the responsibilities will be for the third-party warehouse to ensure that incoming food product and outgoing food product are handled safely in a truck. We want to make sure that your responsibilities for the inbound shipment and the outbound shipment are commensurate with what you're able to influence. The last bullet is intentional adulteration. The preventive controls rules looks at unintentional adulteration. What can happen to a food product from environmental contamination, etc. The intentional adulteration is what happens if a bad actor gets into your facility and contaminates a food product that you're storing. We expect that this intentional adulteration proposed rule will require all food facilities, any facility that manufactures, processes, or warehouses food product, to put in place certain procedures. This could include guardhouses, video surveillance, et cetera, It could become very much a CTPAT-like type of control system. We're watching this closely. We've not seen any signals yet from FDA as to what they'll actually include in the intentional adulteration rule. Another thing that we're looking at, and it's not on FDA's rulemaking list, is the issue of track and trace of food product. As you know, today you have to keep records. You have to be able to document who the food product came from that arrived at your warehouse, and you have to keep a record of the next downstream recipient of that product as it leaves your warehouse. Congress debated whether or not they should implement a more extensive track and trace requirement for food product. Basically a pedigree type system, so they could come to your facility and they could look at your doc records and see every place that product had been upstream from you. They did not go that far, but they tasked the FDA with looking at the feasibility of a more extensive track and trace system. FDA commissioned the Institute of Food Technology to do a pilot program, and unfortunately the recommendation that the Institute of Food Technology came back with is that FDA should implement a complete track and trace or pedigree system on all food products within each sector of the supply chain. Those of you in the prescription drug industry know well what that means. It's a pedigree type system where you would have to have a record of every place upstream from you a product came from, and then pass that pedigree downstream to the next recipient of the product as it leaves your warehouse. We're watching that very closely, of course. In summary, before we turn to the Q&A, FDA is writing the regulations, and IWLA is working closely with our allies in the supply chain to influence the regulations. Compliance dates are ways off. You know, for the most part, there are no compliance dates that you're looking at in 2013, even 2014. IWLA will submit comments on the preventive controls rules by the September deadline. Those comments are being worked on right now. We're looking closely at the rules, including those for food defense, the intentional adulteration rule, and third-party accreditation. And we are concerned that track and trace could become an issue for 3PLs. This fall, I would invite you to consider attending IWLA's annual legislative fly-in. The fly-in is scheduled for September 17th and 18th. On the day before, though, on Monday, September 16th, IWLA's Food Security Council will be holding a day-long workshop on food issues. The workshop will include the Food Safety Modernization Act, but we'll be also having an extensive discussion and presentation on things like the Global Food Security Initiative, changes to the good manufacturing practices, and several other issues. The registration information for the Food Security Council workshop and the IWLA fly-in should be online tomorrow, and IWLA will also be sending invitations out to those of you who are on this webinar today.
Thank you for listening to this IWLA webinar. For more information and for more webinars, please visit IWLA.com.